if you're first on my channel, welcome. I'm really excited, honestly. You guys are encouraging me. You guys are really doing a lot for me, and I'm so grateful. Your girl is super grateful. Thank you so much. Even some persons were asking me, when am I going to upload my next video? Oh my god, see, I'm so sorry for posting this video by this time. I actually prepared this video for a long time, but law school has been on my neck. Like preparation for law school and coupling it with personal life, coupling it with YouTube channel, like it's not been easy, right? So I'm so sorry. I'm so sorry. Please hear me. Alright, so before we start the video proper, the topic, which is consideration, will be divided into part 1 and part 2. Alright, so after this particular video, I'll be uploading the part 2 of consideration. That's to summarize it and to so without further ado, let's get right into the video. Consideration is what each party gives or promises to give in exchange for the other's promise. For instance, if A intends to sell his phone and B is willing to pay 50k for it, the phone is A's consideration or promise, while the 50k is B's consideration or promise. In the case of Oyebanji versus Fowowe, consideration was defined as something of value which must be given for a promise of benefit. Summarily, a contract is basically a bargain between two parties, each receiving something of value. This something is described in law as consideration. Furthermore, in the case of Shah Nasaya versus Awati, it was held that a contract in which consideration has not been met is one that can be said to have been breached. Note importantly, consideration is an essential part of a valid contract, which without it, such contract is unenforceable. We have rules governing consideration. A. Consideration need not be adequate, but must have some value in the eyes of the law. That is, the promise of each party must have some real or economic value in the eyes of the law. B. Consideration may be executed or executory. An executed consideration is often seen in unilateral contracts. For instance, when there is an offer of reward for a lost article published by the police to the whole world, this is a unilateral contract or unilateral offer. Anyone who finds such article is liable and entitled to the reward so stated or published. When you hear of unilateral contracts, you know that it is talking about one person. So it's a contract that involves a particular person and any other person that is interested with the offer stated by that one person. Alright, so when you hear uni, you know that it is just one person who is making the offer to anybody that shows interest to his terms. Thus, in unilateral contracts, the offeror has no obligation until the offeree has fulfilled his own part. Executory consideration means an act to be done in the future. This is seen in bilateral contracts where both parties promises themselves the performance of an act that is to be done in the future. So executory has to do with futuristic performance of obligation, whereas executed has to do with the immediate or past performance of an obligation or a duty in respect to the contract. C. Consideration must move from the promisee. This simply means that it is only a party to the contract who has furnished his own consideration can enforce the contract in an event of a breach. So a non-party, someone who is not part of the agreement, someone who is not part of the transaction, cannot enforce a contract. Also, someone or a party who has not furnished his own promise, who has not done his own part, in respect to the contract cannot enforce the contract when there is a breach. B. Consideration must not be passed. When a party performs an act before a promise is made to him, he cannot claim that his previous act is a consideration for the promise. Thus, consideration must be made after the promise of the offeror has been made. For instance, if A clears B's land philanthropically and B, upon seeing such act, promises A 10,000 naira, A cannot sue B for the fulfillment of his promise of 10,000 naira because the act of clearing the land was done before the promise was made. Thus, a valid consideration must be an exchange of promises and not a reward for an act already done. Exceptions to the rule. The rule of past consideration is not absolute. There are few exceptions where past consideration would amount to a valid consideration in law. A. Where the subject matter of the contract was requested by the offeror. So where the act of A was actually requested by B, right? Then the fact that A performed the request, A is liable and entitled to the 10,000 naira. B. Payment of such acts was within contemplation by both parties. So not only was the act of clearing the land requested by B, there was a conversation that if he does it, there will be a payment. C. There must be the existence of all the elements of a valid contract. So all the elements of a valid contract must be present. Instances like offer, acceptance, consideration, intention to create legal relation, capacity, all of these elements must be present in that transaction. D. The payment of benefit must have been legally enforced. E. Where a statute bad debt has been acknowledged in writing by a person, revives the debt even if it's past. E. Consideration must not be in the nature of performance of an existing duty. Where a party is already obligated to do a thing and he eventually does it, the doing of such act would not be a valid consideration for a promise made to him. For instance, if A is obligated to sweep the whole compound for B, if he enters into a contract with B, he cannot use the act of sweeping the compound as a consideration to the new contract because B is already entitled to it. I hope this clearly explains the exception letter E rather. However, if A does more than sweeping the compound, then the actual act may be a new consideration. The various circumstances that explains this, however, are A. Duties imposed by law. People who are obligated by law to carry out public duties, for example, police officers, such duties are not deemed to be considerations because they are merely carrying out their primary assignment. Now, where the act is in excess of duty imposed by law, such excess duty becomes a consideration. Let me give a quick instance. In a situation of police officers, you know that their primary duty as police officers is to secure and guide the citizens of Nigeria, right? And they are being paid by the government. So no citizen is to pay a police officer because they are public officers, right? Now, if a citizen calls a police officer and tells him to escort him to a particular event, right, like let him be his bodyguard for that event, the act of escorting a citizen for a particular event is not within the primary assignment of that police. So it becomes a new consideration from the police officer to the said citizen, and the citizen is expected to pay the police officer because the act of bodyguarding you is in excess of his primary assignment. I don't know if you understand. Furthermore, we have duty imposed by contract. A party who is said to be under a contractual obligation to another party, if he discharges such obligation, he cannot say that the mere act of discharge of obligation is him furnishing a consideration. All that the party has done is a performance of an existing duty imposed on him by the past contract between him and the other party. However, if the act is in excess of an existing contractual obligation, it will constitute consideration. C. Duty imposed by contract with a third party. Where a party owes another party a duty and he uses such duty to create a new contract with a third party, the law recognizes such duty as a valid consideration in the new contract with the third party. Waiver or variation of contractual rights. Where a party partly or wholly waives, waiver means overlooks, right? So when a party partly or wholly waives or overlooks or vary his right in a contract, such waiver or variation is not binding unless there is a consideration given for it by the other party. So for instance, in an instance of debt, if A owes B 100k and B says give me 80k instead and take the 20k, the law still gives B the right to recover the balance of 20k from A even if it was waived by B. This is because A did not do anything as a consideration for the waiver of the 20k. This rule was established in the famous case that is called the Penels case. Now, the instance I gave you previously was the fact of this case, and that is what the court held. Now, there are exceptions to this rule. A. If the time slated for the debt to be paid has not elapsed and the creditor requested for the lesser sum as full discharge of the whole sum before the expiration of the time, he cannot claim the balance later. So if there was a stipulated time for payment of the debt, right, and the creditor requested for a lesser sum before the expiration of that time, the court will not give him that liberty to request for the balance. Where the creditor requested for the lesser sum alongside a good or benefit attached to it, it would amount to a good consideration. So for instance, if B tells A to give him 30k out of the 100k together with a pint of rice as full discharge of the whole debt, B cannot claim the balance because there is an additional act, which is the pint of rice, which the law sees as a valid consideration. Remember, consideration need not be adequate but sufficient. B. Where the debtor owes too many people at the same time with insufficient resources to pay fully. If the creditors agree that he should pay them in part in discharge of the full debt, such agreement is binding on them and none of them can subsequently request for the balance. The last but not the least on this part is that another major exception to Penel's case is something called promissory estoppel, and this will be discussed in part 2. Thank you guys for sticking with us up till now. Thank you so much, and please ask your questions in the comment section. Do well to ask me any question. If you know that anything I said in the video was not quite clarified, okay, I'm still available to clarify you in the comment section. Please don't forget to subscribe, like and comment. Thank you so much, and to see you in my next video. Bye.